Six Flags Over Georgia, featuring the Batman roller coaster rides, is one of America's most favorite playgrounds. But for 5 long years, it became one of America's most historic courtroom battlegrounds, pitting a small group of investor owners in a David and Goliath struggle against its managing partner, one of America's most powerful entertainment companies, the Time Warner Entertainment affiliates. And even when Time Warner's vice chairman, Ted Turner, took the witness stand to plead for leniency, he didn't sway the jury one bit. Today, the Insider exclusive shows you how Jim Butler and George Freihofer, partners at the Butler, Wooten, and Freihofer law firm, took on this Goliath, Time Warner, in one of the longest and biggest roller coaster rides in American legal history, and showed how Time Warner affiliates took the Six Flags owners for a big ride, stalled them, overcharged them, and then systematically cheated them. This case went all the way from a little old Georgia courthouse through the legal maze of the Georgia Appellate Court, the Georgia Supreme Court, and then on to the United States Supreme Court, and back again for another round until a final victory with a record $454 million verdict. I'm Steve Murphy, and this is the Insider Exclusive, live from Atlanta, Georgia, at the Butler, Wooten, Freihofer firm. It is my great pleasure to introduce 2 outstanding trial attorneys to this show. Jim Butler, welcome to the show.
Thank you, sir.
And George Freihofer.
Yes.
Welcome to the show.
Thank you.
Both of you were involved in this historic $454 million verdict that was paid against Time Warner affiliates. What actually happened in this case?
Basically what happened was in 1967 there were about 100 original investors in Six Flags Over Georgia, and they put up the money to build the park. And the limited partnership agreement provided that at the end of 30 years, the park would revert in fee simple to those limited partners. The deal was set up so that Time Warner, or the general partner of the park, got about 70% of the cash flow, and the limited partner in the park got 30% of the cash flow. About 1991 or so, Time Warner became the general partner.
They bought out the old managing
Right,
partner.
they bought out the old managing partner. And however, there was a catch. Most of the Six Flag parks, and there were five or six other parks around the country, were wholly owned by Time Warner. There were only 2 partnership parks. Georgia was one of them. And Time Warner was faced with the prospect in 1998, and this is now, 5, 6, 7 years after they got involved, losing the park entirely, and the ownership of the park would revert to the limited partners. So Time Warner wanted to fix things so that they would end up with a renewed lease on the park in 1998. So instead of managing the park to build up the park and develop the park and increase the value of the park, they managed the park to keep the value down, because parks sell for multiples of revenue or EBITDA, and the lower the revenue, the less they would have to pay for it, and that's what they did, and they did that through a number of nefarious techniques.
Now, when you speak about Time Warner, there are a lot of companies that were involved in this, a lot of affiliates, right?
Right.
Who were some of these affiliates?
Well, basically, Time Warner Inc., or TWX, as its name was on the stock exchange, controlled Time Warner Entertainment, Six Flags Entertainment Corp., Six Flags Theme Parks, and then Six Flags Over Georgia, which was Time Warner's controlled entity that was a general partner in the park.
Right.
Our client was Six Flags Limited, who was a limited partner. And basically what happened is Time Warner controlled all of the affiliates, all the way down to Six Flags Over Georgia, Inc., and controlled their decisions and their spending to drive down the value of the park so that they could acquire the park at a discount and not pay our original investors what they should have been paid for their investment.
Now,
the problem was that Time Warner was a partner with the investors, the general partnership that owned the park. And as a partner, they owed what's called a fiduciary duty to their partners. Fiduciary duty is the highest duty known to the law. The obligation of a partner, for example, under fiduciary duty law, is to treat his partner's interest as more important than his own. And Time Warner did just the opposite. they actually went out and sought to drive down the value of this amusement park for the purpose of cheating their partners.
Right.
It's the opposite of fiduciary duty.
We happen to have a chart here, which is called a milk or build chart that Time Warner actually developed about what they wanted to do with this Six Flags Over Georgia, right? Let's go to that and look at that, and would you explain it, please?
Basically, that was one of the documents that was ordered produced by the court, and what it demonstrated was two choices or two routes Time Warner could have gone managing the park. They could have built the park, invested in the park, increased the value of the park. That was the build the park part of the equation. The alternative was to milk the park, which was to deprive the park of capital expenditure, deprive the park of major rides, take money out of the park, and not do anything to enhance the overall value of the park and build EBITDA, which built the total value of the park.
There are some phrases that you're talking about. EBITDA. Would you explain that to our audience?
That's earnings before income taxes, depreciation, and amortization. That's a very key concept in theme park sales and theme park value, because parks sell for a multiple of EBITDA. For example, the evidence in our case was that theme parks sell for between 10 and 12 times EBITDA. So if EBITDA is at $20 million a year, the park would be worth $240 million. If EBITDA is at $40 million a year, then the park could be worth $400 million.
Right, and we have a couple of charts that we're going to show right now, which are demonstrating what you just talked about, which is Six Flags Over Georgia, EBITDA versus the owned parks, the difference, correct?
Right. Basically what happened is that this chart demonstrates the result of depriving the park of capital expenditures and essentially draining the park and not building the park. It kept the Georgia park's revenue flat, which is the blue line you see there, even almost decreasing. However, the owned parks, Time Warner's owned parks, which they allowed to invest in major rides, had a meteoric rise in revenue, because that's the way you build revenue in theme parks. You put in major rides and you have a stair-step increase year after year.
And one of those major rides was the Batman ride, wasn't it?
Right.
That they deprived the Six Flags Over Georgia park, putting it into the parks that they own, correct?
That's correct. The Georgia park had already ordered the Batman ride to be delivered to the Georgia park. And the Batman ride was the most successful ride in the history of theme parks. No other ride in the history of theme parks all over the country had made more money and driven more EBITDA increases than the Six Flags, or excuse me, than the Batman ride. And they took our Batman ride that was destined for Georgia and sent it to St. Louis. Right. And instead of the Batman ride, we got the Viper, which was a ride taken out of St. Louis that had been sitting in the cornfield for 6 years.
Right. Now, we have another chart which we're going to show, which is this major ride capital expenditures versus as a percentage of the revenue. And you can see actually how they were doing this in a chart. It's interesting that you bring up this Batman ride, because it's, in essence, and I want to really emphasize this, Time Warner owned, what, 5 parks?
5 wholly owned parks.
Yeah, and they managed these other 2 ones, Six Flags Over Georgia,
parks,
right?
Correct.
They made more money with the ones they owned, and they could see this as a moneymaker, right? So rather than adding any additional ways to increase the revenue for the ones that were managed, which you said they had a fiduciary duty, they deprived them of that so they could drive the price down to eventually what?
Well, as low as possible. Time Warner really wanted to buy the Georgia park.
At the low price.
At a lower price. Failing that, they wanted to sign a new management contract that was beneficial to them, more beneficial to them, because the value of the park had been driven down. The Batman ride was just a marker for the general policy of Time Warner, which was to deprive the Georgia park of attractions and even maintenance.
Yeah.
I mean, they didn't even do a very good job of maintaining the park.
I understand they withheld about $7 million worth of maintenance on the park. What are some of the other dirty tricks, if you will, that the management pulled on Six Flags Over Georgia to drive the price and the value down?
One of the things they did was they bought up, in the name of Time Warner, the property surrounding the park.
So they couldn't expand.
So they couldn't expand. So if Time Warner was unsuccessful in buying the park, the park couldn't expand, and that would make the park unattractive to other bidders. They signed key employees of the park to exclusive contracts with Time Warner, not with a partnership, but with Time Warner.
Every year, the partners would derive revenue. And I understand there were some years where they were driving, what, $18 million a year or something like that, you know, from the two parks? So with the...
Well, the two parks were separate, separate partnerships. There was the investors in the Georgia park. Some of them may have been investors in the Texas park, but not most of them.
But every year, as the revenue decreases, you have some pretty sharp investors, don't you, that are wondering what's going on?
Well, we did, and you know, we had a particularly smart and incisive client in Avram Salkin, who was the general partner of the limited partnership, and he saw what was going on, and began to investigate it, began to determine what was happening, and that's when he got legal representation for his folks.
Well, one of the problems he had is that Ave and the other investors had a difficult time getting straight answers from Time Warner.
We are going to cut to an interview right now with Ave. He can talk about why he selected your law firm in the first place, because you had to have a sharp law firm to understand these numbers.
In 1997, I was involved in a situation where I needed to search for a business litigation firm in the Atlanta area. I went to Atlanta along with a senior partner of one of the local Los Angeles firms and a member of our firm that was a 40-year litigator. And in the process, we interviewed 8 law firms in the Atlanta area. The one that stood out was the Butler Wooten firm, primarily because they were innovative. In particular, they pointed out how they could use video depositions to tell the story to the jury through the opposing side, which would be far more convincing than if it was through our side. They also had extensive jury experience, and they appeared to communicate very well, which turned out to be the case. We were very delighted with the way the case was handled. At first, they had to oppose motions that were made, and they did a very thorough job of filing papers with the court to point out why the motions were not well brought. During the course of discovery, they had difficulty in obtaining documents from the other side, persisted and got favorable orders from the court. And at the trial, they really had a good relationship with not only the judge and the opposing counsel, but they related very, very well to the jury. And as a result, their presentation was just excellent to enable us to tell our full story in order to have the case determined.
And you typically don't handle these kind of cases. You were generally known as a fantastic personal injury firm, right?
Personal injury and products liability. But, you know, all of the senior partners in this firm started their careers doing business litigation. So we've done a lot of business litigation. As a matter of fact, the first 5 years I practiced law, that's all I did, was mostly business torts litigation. So we had by far the best verdict and settlement record in Georgia. And Steve Myers and Ave Salkin had this bright idea that since this was a case likely to go to trial, they ought to hire lawyers who really do try cases, and lots of them. So instead of hiring a large firm that's used to litigating and billing by the hour, they decided to hire us. But that's how they came to us, as a process of interviewing just about every large firm in Atlanta that was not conflicted. We associated Gerald Davidson, who's out in Gwinnett County, a good friend of ours, as local counsel. And we decided that we liked being in Gwinnett County because while jurors out in Gwinnett County supposedly were not good in your typical plaintiff's personal injury cases, this was a case about a general partner literally cheating the investors, cheating its own partner. And we thought this was the kind of case that would have appeal to any kind of juror.
Sure, because it's David versus Goliath.
Well, not only that, it's actively trying to cheat someone to whom you owe the most highest duty the law recognizes. And that's the crucible of this case, is the concept of fiduciary duty. There is no duty in the law, not spouse to spouse, parent to child, that is more held more sacred than fiduciary duty, partner to partner. And there's a reason for that. our whole economic system depends upon people in business together who have a fiduciary duty, such as partners,
Right.
being able to rely upon one another.
It's a
And if they
trust.
can't, if you can't have that modicum of trust, most economic deals collapse.
Yes.
So that's why since ancient England, fiduciary duty has been deemed sacred.
A lot
And
of
Time Warner, and the incredible thing was, as we got into this case, we realized that Time Warner and its lawyers, Steve Ross was a lawyer, one of the executives of Time Warner Entertainment, were fully aware what fiduciary duty meant.
Sure.
And they were fully aware that they were deliberately and calculatedly violating their fiduciary duties to their partners. And we never could quite decide what was going on in their minds. Did they just think they were going to get away with it?
I believe that.
Obviously they didn't.
Yeah, I believe that was their intent. And one of the things that I want to show right now is Robert Daley, who was the chairman and the co-counsel of Warner Brothers.
Co-CEO.
Co-CEO
Right.
of Warner Brothers. We have a video taped deposition, which we're going to show right now, where he's explaining what his fiduciary duty is to anybody that works with Time Warner. And let's go to that right now.
Would you agree with me, sir, that one partner has a right to expect the other partner to be truthful?
Yes, I would.
Would you agree with me, sir, that one partner has a right to expect that if he asks the other partner for information about the operation of the partnership business, he'll get it?
I would think so.
Would you agree with me, sir, that one partner has a right to expect the other partner not to withhold information about the partnership business?
I would think there should be open communications. Yes.
Would you agree with me, sir, that one partner has a right to expect the other partner to not earn undisclosed profits in dealing with the partnership business?
I think that we should live within our agreement, yes.
Well, obviously, Robert Daley knows exactly what fiduciary duty is. Tell our audience exactly some of the things that Time Warner, this major conglomerate, an American icon, what they were doing to these investors.
One of the most important things they did was starving the park of capital expenditures, that is, starving the park of major rides, which drive EBITDA up and which increase the overall value of the park. They bought up land around the park to keep the park from expanding. They signed key employees to exclusive contracts so other bidders wouldn't have the key park employees if they did not get the deal. They used park employees to fly around in a helicopter with Bob Pittman, one of the executives, looking for a site to build an alternative park to compete directly with their own partner's park. They took millions of dollars out of a soft drink exclusive marketing provision and used it to increase their equity in the underlying park.
Let me interrupt you a minute. Just to focus on those two things. There's a real simple word for that sort of conduct. Using partnership funds to try to find a site to build a park competing with your partner's owned park.
What's that simple
It's
word?
stealing.
Yes.
Or the Coke deal that Pittman engineered. It's absolute theft.
Let me ask
It's
you.
stealing from your partners. Now, theft is not a good thing,
No.
generally speaking. In the law, theft from someone to whom you owe a fiduciary duty is considered hideous.
Mm-hmm. So they basically overcharged people, sabotaged them, and the whole nine. Did they think they would not be found out, or didn't they care?
That's been the mystery for us for a long time. All I can assume is that the Time Warner executives assumed that these claims in this case would be handled like most such claims between corporate parties are handled, and there'd be a war of attrition, a paper war, and hundreds of depositions, and it would drag on for 3 or 4 years, and then the parties would settle it.
Yeah. In other words,
for pennies on the dollar.
they hope that Time Warner is going to be paying their legal bills, right? they hope that the plaintiffs' attorneys, when they see these mounting costs, eventually say, hey, we need to settle this, right?
Yes, and I think that was the wisdom of Abe Salkin and Steve Myers in handling somebody who, when we first saw the case, wanted to take it to trial.
Right.
We were hired in this case in April of 1997, and we tried it in November of 1998.
Yes.
I don't think we took more than, other than videotape depositions for use at trial, I don't think we took over 12 or 15 depositions. This case was streamlined, and we knew early on what the value of the case was. As a matter of fact, at the first meeting we had here in this office with some litigation lawyers from Gibson, Dunn & Crutcher, and Ave and George DeRoy, and lawyers from Bondurant Mixon, I recall telling them that I thought they had a $75 million case unless we won the privilege war.
Yeah.
And if we won the privilege war,
Yeah.
I thought they had a $500 million case.
Yeah. And you were,
Well,
you were almost right in the money.
We won the privilege war,
Yeah.
and we got a verdict for $454 million.
Yeah. Now let's talk about our audience that's unaware of what this privilege war is. So I'm gonna start this out by saying, what were some of Time Warner's lawyers' dirty tricks, if you will, to prevent you from getting the information you needed to win your case?
Well, in litigation with corporations, it's not uncommon for documents to be shredded or
destroyed.
That's relatively routine. The difficulty that a corporate defendant faces is that sometimes if it does that, it can't track down all the copies of the document. And if the document then surfaces after the corporate defendant has denied it existed, that's a real problem. Judges will sanction the corporate defendant for that. So what typically happens is any document that's really damaging to the corporate defendant, the defendant will pass through a lawyer, and then they'll claim the document's attorney-client privileged, basically because it's passed under a lawyer's nose. And that claim is bogus. What this firm has done for 20 years now is to actively confront abuse of the attorney-client privilege claims. The attorney-client privilege is a hugely important right. I mean, obviously people have a right to consult with their lawyer, to seek advice without what they tell that lawyer ever being disclosed. And that's important.
Yeah.
But attorney-client privilege is strictly construed, and it's not supposed to be used to hide evidence, which is what Time Warner is doing, which is what corporate defendants frequently do. One of the goals of corporate defendants abusing privilege claims is typically to try to string out discovery, to hold back the documents as long as possible, and hope that they'll get to trial before you get the documents.
Yeah.
And if that happens, then the whole truth doesn't come out.
Yeah.
What happened in this case is we asked the judge to review a number of the documents that Time Warner claimed were privileged, and Judge James Oxendine, who's a very savvy judge, did so. And I'll never forget the hearing that we had where he, after he had reviewed the documents that Time Warner claimed were privileged, he came out to the bench with a stack of documents, and he dropped them on the bench in the courtroom, and he stood there and he said, "Let me tell you something, gentlemen. My law clerk and I have spent the last week reviewing this stack of documents. And most of these documents are no more privileged than I'm Jesus."
Right.
He was angry.
Yes.
And we ended up getting virtually all the documents that we challenged. And not surprisingly, they were the key documents in the case and for the trial. We ended up trying this case on a stack of documents about that thick.
Yeah. Now, you got this huge verdict, $454 million, but you didn't get it right away, did you?
No, we had a very long appellate process.
Yes.
And in addition to being an interesting trial story, this is a very interesting appellate story as well, because this case had two trips to the Georgia, through the Georgia appellate system, the Court of Appeals and Georgia Supreme Court, and two trips to the U.S. Supreme Court. But one of the things we did from the outset We tried the case so as to have no error in the case. We anticipated an appeal. We knew we'd be in front of the U.S. Supreme Court and the state appellate courts, and wanted to make sure we didn't have any error in the case.
Let me interrupt just a minute. That's another thing we told the clients at the first meeting.
Yeah.
We told them that in addition to winning the privilege award, the other key to this case will be anticipating every way the defense lawyers try to inject error into the case and avoiding any error.
So it went up to the Georgia Court of Appeals first. Time Warner then requested certiorari in the Georgia Supreme Court. Cert was denied there. Time Warner then paid the $197 million in compensatory damages plus interest and pursued a cert petition to the U.S. Supreme Court. That took about another year. Ultimately, the U.S. Supreme Court, in its first visit up there, granted the writ and vacated for reconsideration in light of Cooper versus Leatherman. It was a new Supreme Court opinion. It then came back.
Vacated the
punitive damages judgment at that point,
yeah.
or actually vacated the Court of Appeals opinion, the initial Court of Appeals opinion.
Yeah.
And at this point, the Georgia Court of Appeals, the entire full court, all 12 of the judges considered the direction from the U.S. Supreme Court, reconsidered the entire record in light of the new case, and unanimously concluded, all 12 judges, that Time Warner richly deserved the $257 million in punitive damages that were awarded against it. Undeterred, Time Warner filed a petition to the state Supreme Court trying to challenge that. Cert was denied there, and then filed a petition for certiorari again to the U.S. Supreme Court. Yeah. And we waited another year or so for that to happen, and the U.S. Supreme Court ultimately denied certiorari.
Yes.
And so Time Warner ended up paying the $257 million plus interest at 12% through all of these years of appeals. So we ultimately recovered about $630 million total.
Wow.
I believe that it's the largest verdict ever affirmed in full and paid in full in its entirety in U.S. history.
So when you finally knew that the end was there, the Supreme Court was denied their appeal once again, and you knew he had won, what was your feeling?
Probably more relief than anything else. I mean,
it was a long,
this case
5 or 6 years?
7 years.
7 years.
Yeah. So, but it was a tremendous strategic victory.
Yeah.
Both at trial and on appeal.
Well, both of you, your law firm, are to be congratulated once again. I want to thank you for being on the program.
Thank you.
It's a great pleasure.
Thank you.
Thanks for watching. To get more information about our guest and the cases, please visit www.insiderexclusive.tv. Thank you.